Hello and welcome to Legally Speaking with me, Tarun Nangia. This is part 5 in the series on Justice Chandrachud, where we take up and talk about his decision on listing of bail matters, which is proved to be indeed a very important decision that he's taken. It sent a lot of good message to the industry globally that India as a country takes the whole issue of business and investment seriously. This I say because what we have noticed is that whenever globally people look forward to investing in India, they see the issue that people may not be able to get early listing of their bail applications. In fact, lower courts have been reluctant to give bail. That is one another thing that he took up, and very positively so, where we gave a message to the lower courts about this issue. But most importantly, he took up this decision that now 10 bail matters will be listed before each bench of the Supreme Court. That indeed sent a positive message globally that it is now possible to get a hearing quickly. At least if you've been aggrieved, you will be heard. That is why it's so important. And we will discuss this issue with our panel today. May I welcome to you Manmeet Singh. He is partner with Saraf and Partners. He is part of the litigation practice and one of India's leading law firms in this space. Good to see you, Mr. Manmeet Singh, again on Legally Speaking. I have with me Alia Waziri, who practices in Delhi. She's an advocate. Good to see you, Alia, again, and looking forward to some interesting inputs from you. Archit Singh joins us on the show today. Archit Singh appears before the courts, the low courts and the Delhi High Court, and appears a lot on the financial crime side, especially on FEMA, Enforcement Directorate, etc. Good to see you, Archit, and looking forward to some interesting insights. At the outset, may I request Manmeet Singh that in the first 2 minutes, if he lays the ground before we move ahead, we'll go to Alia after that quickly. Manmeet Singh, over to you.
So I think one of the most important aspects for facilitating a good investment climate is to have certainty of process and predictability of process. And what this decision does is it sends out a message that your matter will get heard. Whatever the decision judgment may be, at least you will get an opportunity to be heard. I think that is very important. And it also sends a message to the lower judiciary. It emboldens the lower judiciary that this is now a priority for the Supreme Court as well. And therefore, it sends a message through the entire system. So I think it's a very strong and a positive decision which has been taken by the Honorable Chief Justice to list bail matters as a matter of priority.
Okay, thank you for that opening comment. I'll go to Alia Waziri. Alia, what did you think when you first about this decision from Justice Chandrachud?
Thanks, Tarun, for that question and for having me here. The first thing that I thought of was numbers, figures. There are about 4 crore odd cases pending in India's district judiciary and district courts. And not only that, if you were to go on the Supreme Court website, you will realize that as of 1st December 2022, there are about 69,758, if I'm not wrong, cases pending. And out of this, half are criminal matters. So isme se you can decide how much would be bails. Number one. Number two, you see, we are not the most litigious country. Those countries are like Germany and Sweden and Finland. But what we have understood is that the judge to population ratio is skewed in India, which is perhaps why it takes all this while for a simple matter to be heard. Now, when we are talking about bail cases, we have to understand that this issue involves, and it is an integral issue which involves fundamental rights, which can be found under Article 21. It involves the crucial right of personal liberty. Whether it's a valid ground or an invalid ground can only be found after inquiry, can only be found after proceedings have commenced and heard from both parties. So without going into the merits of whether it's a good case or a bad case or a shoddy case or a false case or if it's parole or furlough, without going into any of those things, simple bail provisions, we have to understand that this is an integral right, and without even getting an opportunity of being heard, there are people languishing simply because they just can't afford the opportunity of being heard.
Okay, thanks. And I appreciate you dishing out facts and figures as usual. You do in whenever you've participated on Legally Speaking. Thank you so much for that. I'll go across to Advocate Archit Singh. Archit, I want to ask you about the timing of this decision by the Chief Justice of India. Do you think the timing is crucial?
Tarun, the timing is absolutely important over here. Now, let us look at what has transpired in the last few decades. We've had some decades ago, we had certain principles that we believed in, such as jail is the rule, bail is the exception, guilty unless proven innocent. All these principles in today's time, the way investigations are carried out and the way the proceedings are being carried out, have turned on themselves. Somewhere, bail has become the rule and jail the exception. Today, I, as a litigant or I, as an accused, have to actually prove why I should be given bail rather than the agency coming to the court and saying why this person ought not to be given bail. So these are some facts which are very important. Now, why the timing is important? Because this is a top-down message that the Supreme Court sends. If the Supreme Court is taking personal liberty and accessibility to justice at the higher pedestal, then the entire judicial system across the country should take note of it. And I think that is where the secondary statement of Justice Chandrachud regarding the lower judiciary becoming emboldened comes into play. That the contemporary view of the fraternity is that bail ought to be given precedence. As Alia correctly pointed out, whether it's right or wrong is a point that is of merits, but it has to be heard. That is a point of precedence.
Okay, thanks for that opening comment by Archit Singh. I'll go across to Manmeet Singh at this point. Now, you're the law firm that deals with a lot of international clients. And also on the M&A side, other side, you do a lot of work. You end up doing litigation work for them also a lot, many times. I want to understand, what does the investor feel about India and what message is going to the investor community with this kind of a decision by the Chief Justice of India?
So it happens very often that, as part of compliance, there are so many compliances in this country. You end up tripping a compliance, there is a penal provision, or you could end up in a commercial dispute to which, which is then abused, and a criminal angle is brought into the matter when none exists. So those kind of situations are becoming very, very frequent. So therefore, I think something like this sends a very positive message that even if something like that were to happen, you will have recourse to justice. You will not languish in the jail. You will be able to get a hearing and make sure that the process of law protects you. So I think it certainly sends a very, very positive message. And this is actually in sync with what the government is trying to do. This will certainly boost the investment climate, in my view.
Thanks for that input. I'll go across to Alia Waziri. Alia, if you could share this thing with me, that businessmen generally have a fear of arrest. Who will run their company if they are put in jail? That is also a worry. Keeping that in mind, and there have been many arrests recently. You saw a lot of business being prosecuted. Many times they say that throw us in jail when we are convicted. But even while the trial has not commenced, the procedure of court is going on. Why should be kept in? Do you think in those times it's a very positive sign that has come out from the Supreme Court and the Chief Justice of India himself?
Of course, it's extremely welcome. It's progressive. It reflects on a system that pedestalizes access to justice, that pedestalizes personal liberty, regardless of your crime. And I hate to say this. I hate to be the only person on your show who's saying this. But whether it be NDPS, whether it be UAPA, whether it be white collar crimes, you are not prioritizing the nature of the crime. You are saying bail is an accused in a non-bailable, non-compoundable offense. An accused in a non-compoundable offense has a right to bail. Like Arshit earlier said, we are seeing a very dramatic, very drastic shift from jail is usually what is going to happen and bail is the exception. We are hearing, we are listening and witnessing a drastic change in mentality, in outlook. That here you're giving relief, you're giving a form of reassurance to litigants, whether they be businessmen, whether they be ordinary citizens from non-commercial backgrounds. You are giving them the reassurance that should something like this happen, whether it be merited or not, whether you be actually at fault, whether it be frivolous or malicious, it's not like you will not be given an opportunity of being heard. At least your case will be heard. That gives a form of reassurance to the average person. And that goes a long way.
Okay, reassurance to the average person, the average litigant. That's the message. Very quick comment from you, Alia, on the message to the lower judiciary, or if, as Justice Chandrachud himself likes to say, the district courts, that they also should look at bail in a different light. Do you think that is also a positive message to the district judiciary?
Of course, it's a positive message. Personally, I believe that at least in Delhi, our district courts are very courageous. If you look at the trends, I personally believe they are very courageous, but I do believe that they are overburdened. The judiciary in general in India is genuinely overburdened. If you look at the if you look at the pendency and the general disposal rate, how much can a person listen? But if there is a top-down approach, if there's a specific eloquently worded message which says that you have to look at, you have to pedestalize and prioritize personal liberty, and you have to hear, let's say, a given number of 10 bail cases in a day, that is a very clear message that in your busy schedule you have to wriggle out and find a way of hearing at least 10 bail matters in a day.
That's something that has reassured a lot of litigants who are applying for bail. Indian, earlier what you say is correct. I'll go across to Advocate Archit Singh. Archit, when you deal with a lot of these businessmen who've been incarcerated or in jail for quite a lot of time, you may have got some insights. If you could share some of those insights with us about what fears do businessmen have when there is an issue of arrest and bail. What is the primary fear? Why is this such a big issue? What is very specific for India? Could you share some inputs with us?
Sure. Now, Tarun, before moving to bail, let us consider arrests as a point of view when the investigation is on course, right? The mere fact, the way investigations in India begin, right? The threat of arrest comes into play. Now, let's categorize the Indian businesses into two broad categories, although somewhere someone may criticize me for doing that, but fair enough. We have promoter-driven businesses, that is sometimes family-driven, or it may just be promoters. And sometimes we have managements that are more as westernized and professionalized, correct? In both of these situations, there are primary problems that come into play. Firstly, if a businessman is arrested who is a promoter himself, the entire business goes into a haywire. The entire system and ecosystem of the business comes into play to try and save the promoters from himself, from the agencies, whereas the business aspect becomes secondary. Even otherwise, the secondary problem which both kinds of businesses face is loss of talent. The moment an investigation ensues and the agent, any company is under a threat or a business is under threat, could people start leaving the business? No one wants to be embroiled in getting questioned, being called on a regular basis to the investigating agency, which often happens, right? You can have fantastic people who will just say, like, sometimes I call someone and say, hey, how are you? Where are you now? Like, boss, I left that company, just too much daily in and out. I can't do that, right? I have nothing to do with anything, whatever it is, that company's problem. So this is the kind of problem the companies start facing and the businesses start facing when the investigation with a threat of arrest starts coming into play.
But thank you for sharing that innovative insight, Archit, because we never thought of it that way, that talent retention becomes an issue. It's always, we thought of promoter being arrested and but if there is no talent to run the company, how you run the company? And that's why arrest is, in both kinds of circumstances, is important. And it's also relevant because I think in the past few years, we saw a lot of senior executives go in jail. Later, they were let off. But it creates so much of fear psychosis when they are called for questioning and then threat of arrest. Fair point by you. I'll go to Manmeet Singh from Saraf and Partners. Manmeet, I want to understand from you, you also study the Indian business ecosystem closely. When the message goes out that in India, a lot of these kind of arrests happen, many times you've seen that for some minor dispute at the lower level, the district court may issue a warrant of arrest against the CEO and the MD himself in many cases. Do you think that in that kind of a climate, the message from the chief of the judiciary, the Chief Justice of India, in a sense, shows that the future times are going to be better, pro-business, pro-investment climate? A few words on that.
So absolutely, Tarun. I think it can be very unnerving for senior managements to get named in all sorts of these FIRs which happen. And as I was mentioning earlier, it's now routine and a matter of strategy to try and convert a commercial dispute and try and convert to wrangle. We've seen examples when senior Korean executives got named in criminal complaints and FIRs. So I think, therefore, as part of what we are seeing, it certainly is very reassuring that on the other end, you will have a remedy, you will get heard. And also, one has to consider that in India, the conviction rate is abysmally low. So, in light of that, jumping to arrest people and thereafter, them not getting the bail remedy is obviously something that is not conducive for business. So, yes, I agree with you. I think this would go a long way in allaying the fears.
Okay, thanks for that input and view. I'll go across to Advocate Alia Waziri. Alia, you in the last answer, you interestingly brought that in addition to businessmen, there are other categories of people who don't have an opportunity to get heard. You mentioned various kinds of cases. Could you reflect on that for a bit?
While just talking about bail, and this is very commonly known, the threshold, like for example, under section 436 of the CRPC, there is a regular bail provision for any of the offenses mentioned in the CRPC. However, certain offenses which fall under the ambit of MACOCA, NDPS, and UAPA, the threshold for considering whether the person is deserving of bail or not, is it merits bail or not, is much higher. What happens here is the scrutiny that that the judicial mind has to be applied is of a level whether the person on the surface of things, you're usually innocent until proven guilty. Under these three category of offenses, which is MACOCA, NDPS, and UAPA, what happens is, what the judge has to figure out is whether this person is prima facie guilty or not. Now there you are, the burden of proof is very sorry, the onus of proof is on the accused to show that they are not prima facie guilty, and the prosecution's job eventually becomes easier because they have ancillary evidence, circumstantial evidence, so on and so forth. So in such kind of matters also, you are realizing that bail is not being heard, in where anyway bail is not being heard, and the threshold of scrutiny is so high. So all the more reason, and while bail is not being heard, the person is languishing in jail. So, which again is leading to pendencies, leading to under trials, larger number of under trials, which is overpopulating jails. So there are a host of tangential factors which are associated with bail as a recourse in general.
Thanks for that insight. And actually, rightfully so, we're talking of Delhi, but I think across the country, many under trials are languishing in jail.
Yeah, which is creating the problem of overpopulated jails. And then with Corona, it was a problem with vaccines. So you have to understand a host of factors that come with it.
And I have also witnessed this thing in the past few years that the district courts never actually reject the prosecution's demand for, in a sense, when they ask for police custody, they never say that if the person is available for questioning anyways, why do you need his custody? And anyways, then he goes to judicial custody, bails never happen. That's why I go to Archit. Archit, you see this also a lot. Police custody is always for the asking. I mean, it is a foregone conclusion that, custody for 3 days, then extension of 3 days. Sometimes again, one more extension happens till the bail finally, happens, and the judicial custody. But after judicial custody, sometimes it's another challenge to get a bail. I want to ask you, this phenomena of arrest while investigation is happening, and a person involved is available for questioning for the asking. Whenever you call him, he comes for, questioning. Whatever information he wants is being shared. Despite that, this whole threat of arrest, could you reflect upon that and share with us what is the issue here?
So Tarun, this is a very interesting question. Now, recently we had the Antler judgment by Justice Call, wherein we have discussed that 2/3 of persons are under trials. But a large percentage of this under trial is also segregated into people who are actually undergoing a trial where a charge has been framed and the process of the court process has actually started. A large percentage of them are also people who are under investigation and are still in jail. Now, technically, the CRPC under section 167 provides a recourse to this. Not a day more than 14 days in police custody, and not a day more than 60 or 90 days, as the case may be, depending on the nature of the offense, the time period. in judicial custody, correct? Including the police custody of 14 days. Some cases, such as special cases, do have like NDPS has 180 days in commercial in a quantity where it's involved. But anyways, the point is the law does prescribe when you're under investigation, you can only and only be in custody for a certain period of time. However, what has started happening, there is one provision called 173(8), which is for further investigation and filing of supplementary charge sheet. So what has started happening, especially in these bigger investigations, the agencies will come to court, they will file a charge sheet and say, we have done our job, here is the charge sheet, stop the person from getting a like statutory bail, but you know what, we're still going ahead with some more investigations left. Now, what has happened is the intention of the legislature as it was back then and the intention of the law has gone for a toss. The intention was, if you're under investigation, you can only be in jail for some time so that at least the process starts. The court can take cognizance of the offense and the procedure may ensue. But now with this, a person can languish in jail for 2 years and still the agency may say, but further investigation still done, is still going on, but qua this man, it's done. But does that mean the trial can start? It cannot. So the intention has gone for a toss on mere technicalities. That charge sheet, that is the final report is filed, but supplementary report is just an addition to this report, which was the requirement of law. So this is something which is very concerning, and hopefully the way like 130 bail matters a day, hopefully these questions will be taken up by the superior courts, and somewhere some relief and some cognizance to this issue is also taken by the courts.
Thanks for bringing in those insights, Archit. In fact, the supplementary charge sheet issue is very important. It like keeps on people on the hooks forever, rather, and also I think I appreciate a very good set of points that came out in today's discussion on the show. Very interesting points brought out by Manmeet, Alia, Archit, and diverse and different is what I like. Then was repeat. Everybody brought in a different perspective to this issue. And I would like to thank Manmeet Singh from Saraf and Partners, Advocate Alia Waziri, and Advocate Archit Singh for making time and joining us on this really important issue. We will like to do a review of this issue after about 2.5 months, because we will then know how this whole process of listing 10 bail applications has performed, what benefits have accrued, if there are any suggestions to give, all of that. But that's about 90 days from now, that much time. We will have a fair idea. Appreciate all of you joining us and appreciate the viewers for tuning in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.